My son needs to be home as soon as possible. I want to know the lawful reason that he is being detained. Still, there's nothing holding this up. A judge could send him home right now. If a judge wanted to do that, a judge could do it. And there are definitely legal arguments to do it. So let's make those arguments strongly to that judge. Or I would like to speak for the majority of the hearing on the 8th. Because I'm really tired of this. He's getting worse. He's having more emotional fits and episodes. He is suffering. I'm watching him suffer. And I'm not going to keep watching for much longer. I will come to that country, and I will do anything and everything in my power to get him out of there. Because this is a travesty. This is how the system works. What are we going to do? Well, then the system's fucked, and it needs to be exposed for this fuckery.
But for you to get Christian back, you've got to have an order enforceable here, and it's only enforceable here if we can actually get to the point where we can show that the court's got jurisdiction. It only has jurisdiction if we can show that the removal was in breach of exercised rights of custody. I have to say, Nick Brown, on behalf of the local authority, Aidan Vine's very courteous. He's working to try to get it sorted, but he is ploughing a completely different furrow to the one that you're trying to do, which is to get the kid back, full stop, end of story, and then we say to the judge, any other welfare issues can be dealt with in the States as they should be.
Have you provided expert opinion in a case involving the Hague Convention before? It's no criticism.
I'm not offended. Yes.
And you're aware, therefore, are you, of the leading authority of the Supreme Court in the US on how rights of custody are to be interpreted, namely Abbott?
Yes.
Right.
Yes, Abbott. Abbott actually was a case out of our firm.
Was the Oklahoma District Court seized the issue of custody of the child as defined by Article 3 of the Hague Convention? Help me with this.
Well, my understanding of that was whether or not the Oklahoma court, let's make sure we're talking about the same Abbott case. This is Abbott v. Abbott, right?
It's Justice Kennedy's lead judgment.
Oh, you're talking about the United States Supreme Court. I am sorry. My firm was not involved in that. There's an Oklahoma case called Abbott.
Right. Well, that perhaps helps us understand where you are on this.
Right. I'm so sorry.
Don't worry. Are you aware of the lead judgment of the Supreme Court in the US about how Hague Convention cases are to be interpreted, called Abbott?
I have read Abbott. I haven't read it in a long time.
Okay.
Is it in the bums?
I only know it's not. Were you aware before this exchange between us that a court being seized of the issue of custody is understood to vest rights of custody in the court being another body under Article 3A of the Hague?
So if you're going to say that's a point accepted by the US Supreme Court in this case of Abbott, which I haven't got for me.
I'm not suggesting to this witness that under Oklahoma law there is this equivalent of vesting of rights of custody. But this question was carefully drafted.
But if you're not suggesting that, what are we doing?
I'm not going to take time. It's discourteous to the witness. I won't.
Well, no, I think it's more courteous to the bid and to the witness if we understand what these things.
The remainder of Article 3A deals with rights of custody attributed to an institution or any other body.
Yeah.
That a court being seized of proceedings, depending on the subject nature of those proceedings, has rights of custody attributed to it, and the making of an order within that is not required for the court to have rights of custody. It needs to make sure that people understand the terms used. What you understand by the question, the court was seized, or was the court seized?
Let me look at it again. Seized of the issue of custody. Well, the court was seized of the issue of paternity until such time as a paternity adjudication is made. The court is not seized of the issue of custody because the court cannot grant. Let's back up here. The court could grant custody to a third party, but it was a paternity action, and so the request was to adjudicate the child as the biological child of the court. There was no at the time, unless and I'll have to look again, but I don't remember any request for visitation or custody to the father. But I could be wrong about that. There could have been. I'd have to look again.
You don't have any idea what you're talking about.
Yes, there was, in fact. In his motion or his petition on July the 8th, he asked for custody of the child. So Mr. Bond came to the court and asked the court to restrain her from leaving the United States. The court declined to do so.
Thank you. Ms. Hanson, good morning. I hope you can hear me clearly. I'm Aidan Vine. I've got very few questions.
Aidan Vine's very courteous.
Even if the risk of grave harm issues leads my lady to refuse the return order, the fact that he was abducted is a relevant feature of the court's determination of habitual residence. It is an abduction. In terms, even if Article 13b applies, that is determinative of habitual residence under Article 7 of the Hague Convention.
If it was an abduction under the 1980 Convention, tell me how that works.
Lady, if I take you to our argument, I think we had in fact included this. I'm sorry. It's entirely my fault. If I can bring up the skeleton argument you have from us. If we didn't, again, if my lady doesn't have a copy of that, then it's not there.
Where's the argument? Yes.
Forgive me, my lady. I didn't. Sorry, I didn't hear my lord's comment.
Where's the argument in your skeleton argument? Where's the paragraph I should be looking at? Because this is a pretty important point. There's obviously a very realistic chance that I will find no return under grave risk. But if you're right, Oklahoma court seized, blah, blah, blah. I need to know why you say the finding under the 1980 Convention, I'm not saying you're wrong, I understand, finding under the 1980 Convention of unlawful removal automatically means the child is not habitually resident in the country they're now in, and I need to know how long that lasts.
Yes. Well, may I, because I'm conscious, and it's our oversight, for which I apologise. The Article 7 issue is one that you will need to grapple with. And what I propose to do is, because it should have been in our authorities bundle.
Where it should have been grappled with, because it's a pretty key point, I would have thought, is in your skeleton.
Yes. Does my lady have a copy of it to hand, or did you say if you're not connected to the...
Or your skeleton? Or
no,
the
Article 7.
Well, not unless it's in one of the bundles.
Is it in the bundle at the moment?
I'd rather borrow Mr. Vine's book. Yeah, so what am I looking for? The 96th Convention.
Article 7.
Let's see about this. In the 80th Convention, if you've been here for a year, then you require habitual residence, but up to the year doesn't count.
Well, I'm not sure, in fact, my lady, I'm looking at that. I apologise. You asked me why we hadn't put it in there. I know that we looked at this. And I am, if I may, with my apologies, going to go back to how I did before, which is that abduction is not determinative, it is relevant, because I am not sure that those conditions are met.
Is there a case that deals with this?
I know that I looked at this, and I know that I will not have put it in there for a reason.
That's when job gets fun. Ask, and you shall receive.
All right.
You play ball, we play ball. I know you want the goodies.
Welcome to the goodie room.
You paying attention?
Aidan Vine's very courteous.
Swinging past your knees.
Big dick, baby.
Yep.
Aidan Vine's very courteous.
We are here to try to serve your best interests.
Ah!